You're on probation?
Yes.
Okay. Until recently, you had an attorney, correct?
I never knew about the attorney until he showed up while I was in the hospital.
Okay. But
Yes.
that is correct?
Yes.
Okay. Were you aware that in open court,
Objection, Your Honor, as to whether or not I'd ask that the witness be required to give a foundation for anything done while he wasn't in here, considering the rule of sequestration.
involved him, were
Hey,
you
no other
aware
questions?
that in open court, DA Love wanted to remind your attorney
Objection,
that
Your
you're on
Honor,
20 years
that is
probation?
not relevant, and that is improper, and Mr. Schardt knows that.
Sustained.
I have no further questions.
All right. Any other defense counsel?
The court here an objection that the state has regarding the last line of questioning by Mr. Schardt. When the state objected based on the beginning of his question, and Mr. Schardt asked the question that he did, are you aware that the district attorney told your attorney that you face 20 years of probation? This is not the first such kind of question regarding something that is improper that has come up. And I would ask court to remind counsel that those types of, that's not an appropriate line of questioning. It's not a relevant line of questioning. And it's just an attempt to essentially cast aspersions on opposing counsel. And I don't think that that is
We've been doing that all day.
proper, at least not the question that he asked.
Your Honor, I wasn't casting aspersions on opposing counsel. I was casting aspersions of what opposing counsel did. I couldn't
Same
believe.
thing, Your Honor.
Can I finish?
Oops.
I couldn't believe
Okay.
it when I was in court the other day and a DA is sitting there talking to, in open court, to the attorney of a witness
Come on.
and is openly saying, I just want to remind him he's on probation for 20 years. I mean it. And my thing is, she knows why she said it.
Your Honor,
That message was to be relayed to Demikion Garland. I mean, excuse me, to Quindarius Zachary. That's the only reason it would be said in open court. And I assume that Mr. Scheib, in his short tenure as attorney for Mr. Zachary, conveyed that message because that message was made loud and clear in open court. And Mr. Scheib was not the one that needs to testify, according to the state.
Come
Mr.
on.
Scheib's not the one on probation. Mr. Zachary is. So yes, when the state says to about a state's witness to their attorney in open court, I just want to remind him
Look.
he's on probation for 20 years and I'll charge him with perjury and will revoke his probation,
Ooh.
whatever was said, you know, I will rely on the transcript. Yeah, I assume that message has been relayed to the witness and I do believe it was intimidation. I'm not going to
Come
sit here
on.
and say it's witness intimidation and all that. I'm not saying that, Judge. What I'm saying is intimidation in the colloquial layman's term sense.
Facts.
It was a message that was sent, and I wanted to see if he received the message because that is relevant to his bias and motive in testifying.
Your Honor, Mr. Schardt knows that, number one, all of the things that he's representing is being said weren't said, and he still knows that that was an improper question to place before this witness. And to the extent that any attorney is asked something outside the presence of the witness, to ask the witness, was he aware of something that was said outside of his presence? Mr. Schardt has no good faith basis for asking the witness a question. It is not relevant whether or not the witness's attorney, some other person, was told that his client should not commit perjury. And I don't think all of what Mr. Schardt said was even what was actually said. But the question that he asked the witness was not a proper question. It was just an attempt to paint a lie to the jury that someone is trying to intimidate this witness, when frankly, the only person that the witness has been friendly to is all of his friend Shannon's lawyers. And Mr. Scheib is talking to Mr. Stillwell's lawyer, and Mr. Scheib is representing Mr. Zachary. So the idea that somehow the state is trying to intimidate a witness is ludicrous when this, and that the lie that he's putting before the jury that that is what is happening is improper, and he knows it's improper. And I would ask that the court keep him from making those types of false assertions, false representations, misleading representations before the jury under 403.
Note, Your Honor, that not one time when Mr. Zachary was on the stand did I claim that Miss Love intimidated him. I never used the word intimidate in front of the jury. I'm talking about. What I said was, are you aware? And that Miss Love talked about your, I can't quote directly, but talked about you're still on 20 years probation, which was said. I don't even independently know how many years probation is. The only reason I know is because Miss Love said it in open court. So everything was factual. And, I think it's relevant when a DA is saying, and I'm not trying to pick a fight with Miss Love.
We are.
If people are difficult witnesses, we all deal with difficult witnesses in different ways. So I'm not even trying to judge what she said or how she said it. All I'm saying is it was said. And
Yes.
I wanted to know if he got that message, because that message was clearly intended for him. It wasn't intended for Dennis Scheib.
Well, I'm not sure that's true because at the time, I don't think they had yet negotiated the terms of the immunity deal. But Ms. Love, your objection was sustained. So it's really all there is to it.
Your Honor, I think the main thing to it is
Girl,
that
be
Mr. Scheib,
quiet.
he talked.
Miss Love, I'm going to take a bathroom break, okay? I haven't had one for the last couple of times that everybody else has.
Okay. So Judge Whitaker's bladder is now holding Love accountable. Praise God for needing to go to the restroom. There we go. Praise God for restroom breaks. Finally, she's going to do something that she should have been doing, which is shut this woman down. Come on, let's go.
From the past.
Mr. Zachary, I don't know, implicating himself in something that he could get indicted for. We don't have any problem asking the court to compel his testimony pursuant to the same statute that we have had to compel others. We don't have any problem doing that.
All right, well, it sounds like y'all might need to get some sort of an agreement in place between
Right.
yourself and Mr. Scheib.
Definitely like something in writing.
I mean, that's basically what you're saying, Mr. Scheib, right? Is that
That's
he,
Part of the situation.
And also, I think I ought to make Mr. Scheib aware. I just want to make sure he's aware that part of the requirement for that statute is that he not commit perjury on the stand. And Mr. Zachary is currently on probation for a long period of time. And so I'm gonna put that out there. That's it.
all righty.
That one didn't age quite so well.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.